Okay, here we are for another edition of Trustee School presented by Hickman Lowder, Liederbach and Welch. My name is Ethan Welch, and I've got Helen Rapp and George Aljoe will be your presenters today. This is today's March 9th, 2024, and we will be talking a lot about benefits today and what makes the trustees of the types of trusts that we handle, these special needs trusts, why it makes it a lot more difficult to manage, and the nuances of how to administer these trusts. So we try to talk about everything, but we're going to try to talk about as much as we can within the 2-hour allotment we have. If we're recording this presentation, so once again we will be putting this this will be available after the presentation has concluded, and if any questions weren't answered, or you wanted a better explanation, you can feel free to reach out to us, and reach out to our staff, and we'll be happy to talk to you guys individually. So here we are, Trustee School. Let's get it going. So our goal is, as an overview to our presentation, we want to review the basics of the government benefits that is out there. We want to explore the relationship between these benefits and trust administration with these first party, third party trusts, and various tools that we use to manage these benefits. We need to understand the trustee responsibilities, and just generally discuss the trust administration, including how we use advocates and care managers and trust advisors to use this all in as a team. Yeah, there's a trustee involved here, but using a special needs trust and a third party trust, we want to make sure that every base is covered here. So trustee responsibilities, first thing that comes to mind in a lot of cases is there's a trust out there that a family member or a parent created, and they passed away, and now the sibling is or the other child is the next trustee, the successor trustee, and maybe they heard about this this trust that my parent was creating, but maybe they know a lot about it, maybe they know a little about it, but no matter what, where you got to start is read the document yourself and familiarize yourself with the document. That way you can write up your questions in your comments, and when you go meet with your attorney, which is the next step here, is meeting with the attorney. That way you have a good baseline of where to start. And you don't need to be an expert at being a trustee, or before you meet with the attorney, or after you meet your attorney, or 10 years after you become the trustee. You don't have to be an expert, but familiarizing yourself with the document and meeting with the attorney is a great first step. Your obligation as a trustee is you have to use this trust for the benefit of the beneficiary. So reading the terms of the trust, you'll see that who is in charge, who is the beneficiary. And who is the trust advisor? Who's the advocate, and how do all these roles intertwine? But ultimately, your beneficiary is who you want to be, overseeing and making sure that, their needs are being cared for. And, you know, primarily it's a financial need because you've got the checkbook as trustee. You're managing the finances and making distributions on behalf of the beneficiary. But these obligations are all derived to what's in the best interest of the beneficiary. Much of these trusts that the trustee is overseeing, that we create for benefit protection, the trustee has the sole discretion to use and not use these funds. And there's a good reason for that. The reason for that is that's what the law says, that the trustee should not have any, any, or the beneficiary should have no way of getting that money. It's all up to the trustee to use that money for the benefit of that person. That's in the federal law, that's in Ohio law. For these special trusts that we administer or help our clients administer, that's one of the main requirements. So it's all up to the trustee to use this money for the benefit of the beneficiary. And fiduciary, just as if people don't know, fiduciary is any person that has oversight over another. So that could be a trustee, that could be an executor of an estate, that could be a guardian, that could be your financial advisor. They have fiduciary obligations as well, and fiduciary responsibilities. So fiduciary is the over-encompassing term, and you each have a trustee or executor, power of attorney, with each specific document or role. The financial responsibilities then for the trustee, well, obviously we need to invest this money. We have to disperse this money. There's a lot of record keeping, and there's taxes that need to be accounted for. What makes this trustee of a special needs trust a lot different than a typical trust is there's a lot more reporting requirements, not only to the beneficiary and maybe even to like family members, depending on what the trust says, but there's a lot of reporting requirements that need to be done to Medicaid and Social Security, that a typical trustee doesn't have to do because there's no benefits involved. Here, there's a lot of benefits involved, and the government wants to know what's in this trust and how this trust is going to be used. So reporting is done at annual redeterminations of the beneficiary to determine if benefits are still being used. The advocacy requirement that a lot of our trusts entail, making sure that not only the financial responsibilities and obligations being made, but hey, is this beneficiary who is disabled, do they need any care above and beyond the money aspect? The other not requirement, but responsibility is if you have or you represent to have a special skill, like you're an attorney or you're an accountant or you're a financial advisor, well, that raises the bar of your responsibility. So if you represent that, yeah, I'm an attorney, I'm a special needs attorney, and well, more than what the typical person has. So that raises the bar of your responsibility according to the law's eyes. So specifically then, dealing with, fiduciary duties and self-dealing, generally speaking, we want to avoid self-dealing. Because the default rule is we don't want to have any, interruption in benefits. That's our general rule of thumb. We don't want benefits to discontinue, and self-dealing will, if a caseworker sees that, hey, why is the trustee taking a loan out for $20,000? What's going on here, for themselves? Well, is this trust being used for the sole benefit of the beneficiary, or is the trustee using this money? The general rule of thumb is, yeah, there should be no self-dealing. Because if that would happen, the trust would become, it would default to be a bad trust, and the trust would have to be terminated, and the benefits would be lost. So the general rule of thumb is, hey, don't borrow from the trust. Don't invest in your own business with trust assets. Don't purchase from the trust, and definitely don't commingle assets. That means don't commingle the trustee's own assets, and also don't commingle the beneficiary's assets, their own assets and income, with the trust. We want to have a barrier of, we created this trust, we essentially created a new person, and this new person, this new entity, everything will be titled in this trust, and there'd be no interference from other people and their assets, and this will be used for the benefit of the beneficiary. So then the other duty is delegation. We obviously, the trustee, they can, but it'd be foolish for the trustee to do everything on their own. It'd be, you're wearing a lot of hats as a fiduciary. You're wearing a lot of hats as a trustee. So that means that you don't have to manage the investments all by yourself. You can hire a financial advisor to do that. You can hire a CPA to do the taxes. You can hire an attorney to help you with the legal documents. The trustee does not have to do everything on their own. And that includes the advocacy portion. So, you can hire a care manager to, help with placement and help with, getting the right home environment, getting the right caregivers in place. And that care manager can report back to the trustee to make the appropriate recommendations of what needs to be done. Ultimately, the trustee should use, their skill, their care to hire these individuals to help the trustee himself to manage this trust on behalf of the beneficiary. You don't have to do this all on your own. You can always delegate duties. And I believe that's my last slide. So I'm going to hand this over to, or last slide in my first, go around here. So I'm going to hand this off to George. So go ahead, George.
Good morning, everyone. I'm going to pick up right where Ethan left off here about the fiduciary duties, particularly with respect to the investment of the trust assets. Now, Ohio has a rule that in general, a trustee has to manage the assets of their trust the way a prudent investor would. And what is a prudent investor? How does a prudent investor handle that? Through something that's called modern portfolio theory. Essentially, what modern portfolio theory says is that you should hedge your bets when you're making investments. In other words, if you've got $100 to invest, put $50 into something that has growth potential, but then put the other $50 into something where if your first investment doesn't work out, the other investment likely will. In other words, if you're going to invest $50 into high-speed rail company, put your other $50 into an oil company, because if the high-speed train doesn't work out, people are going to be driving more, and so they're going to be buying gas, and so your investment in the oil company is going to do well, right? So you balance that. Again, this is delegation territory here, unless you yourself are an investment expert. Hire this out. You know, if you want to invest, you can find a reputable financial advisor and investment planner, and go with them. And keep in mind, you don't necessarily have to invest the trust assets if it's not in the best interest of the trust, or doesn't further serve the purpose of the trust. And if the trust allows you to simply keep the funds uninvested, which frequently is the case, particularly if you have a trust that doesn't have a ton of money in it. It might make more sense to do something like keep the bulk of it in a CD or money market account, or something more basic, so that you have ready access to it. Generally, you want to have an investment policy statement somewhere in your file that just lays out why you are pursuing the investment strategy you are, and the reasons for that. And that's, again, something that a financial advisor can help with a great deal. So moving on then, jumping to your reporting requirements. So as the trustee of the trust, you have the responsibility to make sure that everyone who is entitled to be notified about trust activity is in fact notified. And who are those individuals? Well, first and foremost, the beneficiary, or a surrogate that is named in their place. So in the instance where a beneficiary has diminished capacity, a surrogate can be appointed to receive that notice on their behalf. You have to provide accountings at least annually, but more often if requested. If you've got to do a tax return, you are responsible for that and reporting to the IRS. And again, if this can be a lot of work, and if you really have to put in a lot of time and effort and expense into completing it, you can potentially be entitled to trustee compensation above and beyond what your normal typical compensation is. But who else you might have to report to? Well, if your trust is court supervised, you have to report your accountings to the court, and in fact, you have to get court permission to actually use trust funds. Typically, what you do is you get an annual or a semi-annual budget laid out, so that you are able to use the trust funds kind of on a day-to-day basis. But again, if you're court supervised, that means the court is the one that ultimately has the say over what the trust can be used for. And then again, to benefit agencies, SSI, Medicaid, upon request, if the agency wants to review eligibility, you have to provide what the trust has been doing, and SSI, Medicaid have an annual renewal redetermination process where they will typically ask for information about trust activity to verify eligibility. So you would have to provide those reports at that time as well. Okay. So we mentioned trustee compensation. Typically, in most cases, trusts will provide for some kind of compensation to the trustee for their efforts as a trustee. Typically, we will structure our trusts to refer to whatever your local court, probate court, provides for their trustee fee schedule. or what a professional trustee, a bank or a trust company would charge, their fee schedule. There's a reference to something that gives you guidelines as to what is reasonable. And so here's an example. For the first $1 million in trust assets, annually the trustee is entitled to $12 per thousand, and then you can see it goes from there. But again, if you as the trustee have to go above and beyond what would be typically expected of your role, you have a year where the beneficiary demands 8 accountings. And you just have to put in a ton of time and effort into that. You could be entitled then to compensation on top of what your typical compensation is, because you did activities that weren't typical for your trustee. So I think that's good for compensation. So administering a special needs trust has some additional wrinkles to it and challenges. One, your primary beneficiary likely has some amount of diminished capacity, perhaps not, but in many cases so. The primary beneficiary likely has
George, sorry to stop you here. We got
Yeah.
a couple of questions about compensation. One question is, I'll read these to you so you can answer directly. Does the compensation still apply if the trustee is not actively managing the investments but only doing reporting, other administration?
I think yes. Although what I would suggest is that if you are doing your trustee activities, I mean that fee schedule is what would be reasonable for that level of trustee involvement. Again, the beneficiary and perhaps some other interested parties could require you to justify the compensation that you take. Again, that fee schedule is a guideline. The rule is you're entitled to compensation that is reasonable. So what is reasonable? Generally, if you're in line with that fee schedule, that's going to be okay, but not for sure. If you've done absolutely nothing with in the terms of the trust, perhaps taking a couple $1,000s from that $1 million might not be reasonable. But
I think I would also say that you're delegating this work to a professional. As a fiduciary, then as the trustee, you're not holding this financial advisor, let's say, and letting him do all the work. You have to review the financial advisor in his work. You have to review the investment strategy and maybe do that on an annual basis at least. So you're not delegating all of the work. You're delegating the legwork.
No, I don't get pretty done. So
yeah, and as what I would suggest is that if you have a trust with $1 million in it, in order to meet your fiduciary responsibilities, you're going to be doing enough activity to justify your compensation at that rate. If you haven't been, then you've got a bigger problem than your compensation. It's likely you're falling short of your fiduciary duties.
And then next question, George, is how do these fees compare to professional trust company fees?
Well, one of the things that at least our trust provides is that if your fees are in line with what a trust company charges, that those are reasonable. Different trust companies obviously would have different fee rates. It depends on the size and complexity of your trust portfolio and assets. What I would say is that for some smaller trusts, maybe they have less than $100,000 in it. a trust company's fees would likely be too much to justify the amount of management that they would need to do for that. And it's unlikely that a trust company would even accept being a trustee of a trust with, under $100,000 in it. So
Yeah,
it's really,
I was going to say that, most trust companies and banks that are trustees, number one, a lot of banks don't want to be the trustee of a special needs or third party trust. They don't want that responsibility, that reporting requirement and liability of not administering a trust with benefits involved. That's number one. Number two, banks and trust companies, they do charge the most as a trustee. They charge, anywhere from 1% to 2% of the trust assets as their fee. So they're going to charge the most. Sometimes it's good to have them involved, but they are the most expensive compared to a family member who might take a reduced fee and or no fee. So there's always pros and cons to both options, and it all depends on the circumstances of what to do next.
and just to give you a sneak preview here, we'll be talking later on in the presentation about a kind of a good middle option, which is using a pooled trust company for your trust,
Right.
and that's a good way to get some professional management at a fee at a price point that's not as expensive as a bank or trust company.
All right, George, that's all the questions I got so far.
Okay. So as Ethan pointed out, banks, trust companies, they are often reluctant to be the trustee of a special needs trust, and the reason being is that there are these special considerations when it comes to managing a special needs trust. There's more to it than just meeting the requirements under the relevant trust code and trust law. You also have to manage the complex Medicaid rules, the complex Social Security SSI rules, and a lot of banks are reluctant to do that. Your beneficiary has diminished capacity, so in that sense they aren't often going to be able to assist in letting you know what's going on. So you have to be diligent and keep on top of things happening with them to a great deal. They have social services that they are relying on that are constantly in flux as systems change, rules are changed. For the last several years, we've had a bit of a crisis with providers, care providers being in short supply. These are things that a trust company is not going to be used to dealing with, that are kind of a hallmark of dealing with a special needs trust. The special needs trust, at least the first party special needs trusts, require the state to be a beneficiary, a death beneficiary on that trust for repayment for medical assistance. So they have a special status as a super creditor of the decedent's estate and of the trust, such that what you would typically deal with creditor debtor situation, it's a different set of rules when it's the state and it's under special needs trust rules. The beneficiary may have needs for income that are not typical of what a beneficiary might have. Whether it's higher or lower, beneficiary may need quite a bit of income from this trust if, for example, if they've got care needs and they're not able to be adequately provided by their public benefits. It might be in their best interest to simply pay using trust assets for those care, for that care and services. On the other hand, they may have virtually everything that is taken care of by their benefits, their Medicaid, their Social Security, and they may need only disbursements occasionally from time to time for supplemental things or for quality of life type of disbursement. So it's not, it can be a little different than what is typically. And frequently special needs trusts are subject to court supervision and involvement of the probate court, which is unusual for most other trusts. So having that extra wrinkle there is another thing that makes special needs trusts a little different than typical trusts that are out there. So yeah, hit the next slide there. So
Okay.
as a trustee,
Okay.
what do you have to do, you know, as that trust administrator? So the first thing you and this can be kind of difficult, is figuring out what benefits does your beneficiary have. You know, what kind of Medicaid do they have? And we'll get into all the different sort of flavors of Medicaid a little later on here. Are they on SSI, or are they on Social Security disability? That makes a big difference as to what you can and can't do. So, you know, figuring out what exactly public benefits they have will inform you as to what you can then actually do with those trust assets without jeopardizing those benefits. But you also then have a responsibility to make sure that the care, you know, that the beneficiary is receiving the proper care. Are the caregivers that are involved treating that beneficiary well, doing what's appropriate, covering, you know, their needs? What happens if that caregiver calls in sick or decides to quit unexpectedly? You know, dealing with that. Securing those services, the equipment, and this bullet point, redirecting family and caretakers and beneficiaries. Family dynamics. Oftentimes beneficiaries have siblings or other loved ones who are involved in their life and in their care, but you are the trustee, and so you are the one who ultimately holds the purse strings over this trust. So being able to navigate the requests and sometimes the demands of others in the picture it can be a challenge, particularly if they're your family members too. So they can get a little complicated, and you know, it's up to the trustee to be the one to adhere to what the trust requires and do right and do the best interest of the beneficiary, even if the beneficiary doesn't like what you're doing. You know, you have to say, if I make this distribution that you want, you're going to lose your SSI, and that's all there is to it. So yeah, I'm very sorry. You know, one of the things that helps, and what we encourage parents to do when they are creating their estate plan, is have what's called a letter of intent prepared alongside the trust. You don't want to put this in the trust because it needs to have that complete discretion, but we encourage parents to lay out what their vision is for how this trust is going to be used, and what they see it being used for their special needs child's benefit. That can really help the trustee with guidance as to how to handle things and what they should be doing with those trust funds. Again, they can't be compelled by it. It's not enforceable, but it's good guidance. So let's see where. So I think this is my last slide of my portion here. So basic distribution rules. So I guess I would put, you know, at the very top, the idea is the trust has to be for the sole benefit of the beneficiary. So anything that you're doing with trust funds has to be in some way ultimately for the benefit of the beneficiary. So if you are paying for professional services to help manage the trust, or you are purchasing a home for the beneficiary to live in, or if you are making payments to care providers or goods and services, it's always got to be for the benefit of the beneficiary. Now that said, certain benefit programs will have a problem if you are making payments directly to the beneficiary, giving them cash. There's ways that you can do what's essentially the equivalent of that, but giving cash often can cause a problem. It's usually treated as monthly income when you do that, and that can cause a whole host of problems eligibility-wise. For individuals on SSI, there's a special rule about the payment for food and shelter expenses. SSI presumes that those SSI payments are going to be used for your basic food and shelter expenses. So if something else like a trust is providing those, then the SSI may say, well, you don't need as much SSI because this trust is giving you is paying your rent, or the trust is paying your grocery bill. You don't need as much SSI from us because of that. So that there's a particular rule about that. Again, these are presumptive rules, not absolute. If it serves the beneficiary better to make disbursements that in fact would jeopardize benefits, but overall in the big picture, all things considered, it's better, then that your responsibility is to do the thing that is best for the beneficiary. So yes, you always want to make sure you're keeping the benefits in place to the extent you can, but if it's better for the beneficiary to lose their benefits because they're going to get a better benefit from whatever the trust is doing, you may want to do that.
There's a question, George, that came up. If they don't get SSI and only receive SSDI, can you pay for food and shelter related expenses from the trust?
Yes, Medicaid does have a similar rule about in-kind income. Honestly, I don't see Medicaid enforcing this rule as often as SSI does. But just be aware there is that rule about in-kind income, but typically it's not on the Medicaid caseworker's radar screen, and isn't as much of a consideration when you're dealing with a beneficiary. It's SSI that's got the tight restriction on that. Medicaid, right, not so much.
Yeah, because you can, if the person's on only SSDI and Medicare, then there is no problem with paying for food and shelter expenses. But if that person's still on Medicaid, then, which we'll talk about in a little bit of why that could be the case, then just something to look into. Yeah, keep an eye out.
Good morning, everybody. It's so nice to see so many familiar names on the Zoom. So I'm glad you're all here with us this morning. So Ethan and George have gone over and covered basics of what the trustee's responsibilities and duties are, and a little bit about trust administration. And now we want to talk a little bit about trust assets or trust property. And we tend to use those terms interchangeably, and they do mean the same thing, so don't be confused about that. So what are they? A simple definition is that trust assets are assets that have been titled to the trust or otherwise assigned to the trust for the benefit of the beneficiary. And they can be almost anything. They can be bank accounts, stocks and bonds, investment accounts, real estate, vehicles, artwork, jewelry, any kind of tangible personal property. But it's very important that you remember, once you have a trust, you've come in, you've signed it, it's been notarized, the trust exists, it's in effect. It doesn't have any assets until you take an action to put those assets into the trust. Nothing is automatic. And that kind of became very clear to me that we need to emphasize this. I had a client very early on after I joined the firm that came in, they signed all their documents and they felt great and they were leaving, and the man said to me, "This is like such a relief to us. Now everything we own is in the trust." And I had to tell him, actually, no, nothing is in the trust until and unless you take an action to title those assets or assign those assets to the trust. They're not in there. And that can be something that you do by, going to the bank and opening up a trust bank account or retitling an existing account, or you can do it with beneficiary designations so that these assets will flow into the trust after you've died. Same thing with a house. You can do a new deed and put it in the trust, or you can do a transfer on death so that after you've died, it will transfer to the trust without going through probate. But the one thing that I just want everybody to remember is you have to take an action to get those assets into your trust. So, okay, let's say you've done that. What can you use them for? Typically when we're talking about a trust for a disabled loved one, we're pretty concerned and focused on making sure that, their financial future is secure after we're no longer there to take care of them. So obviously money is a good thing. And so lots of people will make sure that the trust assets consist of sufficient money to provide for their loved ones. But another one that we want to talk about, actually it's the previous slide, would be a house, a residence. And this is sometimes the biggest cause of stress for parents who have a disabled child. Where is my child going to live after we're gone? And in many cases, the parents might be thinking they would like their disabled child to be able to continue to live in the family home, or maybe they want to buy a house and find some roommates, maybe some other similarly disabled people who could live in this house that they purchased. And so this can be, this can be a great use of trust money. The trust can purchase a home, or the home can be put into the trust. But you shouldn't do that lightly. You need to think about what kind of trust you're managing. And George is going to go over this later in the presentation. And so you'll hopefully understand the difference between third-party trusts and first-party trusts. And first-party trusts are also called self-settled trusts, and they have a Medicaid payback component. So you certainly don't want to put the house in a first-party trust that's going to be subject to, Medicaid estate recovery when the person has died. Another thing pertaining to the residence, you need to, if the trust is going to own the house, you need to make sure the trust has sufficient assets or funding that it can, pay the taxes, pay the maintenance, the upkeep on the house, the utility bills. So it's not just the house, it's all of the costs that are associated with the house. The trust has to be able to cover that. And then another thing to think about, if the trust does cover those expenses, it's paying the taxes, it's paying the utility bills, it's paying the mortgage payment, and if the beneficiary is on SSI, well, that's going to be considered income to them. And so there's likelihood that their SSI will get reduced if the trust is used that way. So these are just things that you need to think about. Oftentimes it is a good idea for the house to be in the trust, but you have to really think it through. Another asset that, parents in particular are concerned about, can the trust buy a car for my disabled son or daughter? And yes, it can. It can buy the car, it can, finance the car. And then the question will arise, well, how do we title the car that the trust just bought or that the trust is financing? Do we put the car in the trust, or do we title it to the beneficiary? Do we title it to the parent? And this can be tricky. And there's not any one right or wrong answer, but the trustee needs to be paying really careful attention to this, because they might decide, let's just put the car in the trust, it's titled to the trust, the beneficiary is never going to drive, and maybe they're a minor, or maybe they're just never going to drive. And that's an okay choice, but that might open up some liability issues. What if there's an accident and the trust could be sued, and that could put other trust assets in jeopardy? So you have to think about that. Maybe if the beneficiary is able to drive, maybe it's a good idea to let them hold title to it. That's not going to interfere with their eligibility for SSI or Medicaid. They will both allow you to own one vehicle. So that could be an option. Or, maybe the parent needs to be the title holder to the car. And you can do that. Certain trusts, of course, they're for the sole benefit of the beneficiary, so that might be a problem. But you can get around that by having the trust buy the car, it's titled to the parent, but the trust can hold a lien on the car, so that preserves the trust assets in the trust. So it's just something that is very, very case specific, and the trustee needs to kind of consider all of those things. And we're always happy to talk to you about what makes sense for your particular situation. Okay, so I'm going to leave this topic with having you think about a few types of assets that maybe don't bubble to the top of your thinking, but that maybe should. A good one is the trust can prepay for the funeral of the beneficiary. And you might not want to think about that, but you really probably should. It's a great use of trust assets. And in fact, if it's a first-party self-settled trust, you really want to prepay for it, because once the beneficiary dies, you're actually not allowed to use the trust money to pay for their funeral at that point. So prepaying makes a ton of sense, and so you might want to think about that. And another one that is probably even less commonly considered, but could be a good idea, is the trust could buy a life insurance policy on the life of a family caregiver. Let's say it's mom or dad who's, taking care of the disabled beneficiary and maybe not being compensated. They don't have a waiver. They're just doing it because it's their child. And then they die. And now the beneficiary is probably going to need a paid caregiver. So if the trust had purchased a life insurance policy on that family caregiver, that could at least help. Obviously it's not going to replace mom or dad or family caregiver, but financially maybe it can. So those are just some things, that we think that you should think about. Good uses of trust assets. Okay, that's it for this section.
All right, so now we are moving to a fun topic that everyone just loves. It's the taxes. Taxes with trusts are, much more complicated than an individual's taxes. And we, as a law firm, we have a CPA handle our trust tax returns, because we want to make sure that an expert is taking care of it. So with that being said, I want to just go over the main portions of taxes and what a trustee's responsibilities with taxes are. So a self-settled trust is considered a grantor trust for tax purposes, meaning that any income that the trust generates itself can be carried and will be carried through to the beneficiary's individual tax return. The reason why that's important is the trust tax brackets are much higher than what an individual's tax brackets are. A trust tax bracket, if you make $10,000, if the trust makes $10,000, you're in that 37% tax bracket, which is the highest tax bracket that you can be in, where an individual has to be making, hundreds of thousands of dollars to, get into that ultimate highest tax bracket. So obviously the IRS taxes trusts much more, much harder than they do an individual. With that being said, then the tax of a trust can be carried out to the beneficiary through what's called a K-1. This is through distributable net income. So any distributions that a trust makes, the income that the trust makes through those distributions can be carried out to the beneficiary. And then the beneficiary can report that income on their tax return, where they, the tax rates are much more advantageous. So with that being said, the trusts, yes, you might have to file a tax return. The tax rates are much higher for trusts, but you can carry that out to the beneficiary. So the ultimate suggestion I would say is keep the records as you already do, and if you are comfortable handling a tax return by yourself, then absolutely you can do that. But rely on that delegation of delegating it to a CPA. A self-settled trust is a special needs trust, is a first party trust. You use that person's social security number, but best case scenario or best practice is you generate your own employer identification number for a self-settled trust. And you use that to open up accounts. You use that for the tax return. So that income that you distribute to the beneficiary, that's for tax reasons. There is a difference between taxable income and benefits income. So generally, the income that you report on a tax return should not affect your Medicaid benefits, depending on which Medicaid program you're on. If you're on Magi Medicaid, modified adjusted gross income, that they do look at income on the tax return. So it's always best to speak to your attorney, speak to your CPA to determine what's the best course of action here to not disrupt benefits. So taxation in a third-party trust, these are typically non-grantor trusts. It's very similar to a first-party trust. It's the same distributable net income scenario. The undistributed income is taxed to the trust, meaning you could have to pay taxes with a third-party trust. There are, advantages having a third-party trust compared to another trust. You could be considered a qualified disability trust. So you get a higher exemption. There's other, there's better exemptions for special needs trusts and third-party trusts compared to other trusts. So that's our tax spiel. It's our suggestion is, get a team together to, with the attorney, with the CPA, with yourself, to manage these funds appropriately for tax time, so the taxes and the reportable income aren't going to disrupt any benefits. So next topic here is this care management services. So we, as a firm, we knew, 15, 20 years ago, we saw that there was this need for our clients, that there's a gap in services. This gap in services has, meaning if mom and dad died and sister, the other child of the disabled individual, lives out of state, but all of the services for the disabled child are in Northeast Ohio or in Ohio. Their friends are here, their job is here, their support system is here. Then the sister doesn't want to move that person out, and the disabled sibling doesn't want to move. Well, who's going to be that watchful eye on this disabled child, this disabled sibling? Well, our firm saw that. We hired a social worker to be that person, to be that feet on the ground for the trustee, for that the other family members, so they can do an assessment, they can check in on them, they can answer questions about a health insurance question or a medical question or a caregiving question, sit in on ISP meetings with the DED board, sit in on meetings with their group home, ultimately, provide caregiving services, provide for groceries, everything, provide the care coordination for that support, for that person to be in the community, where that parent was the main source for that disabled child before they passed away, before they couldn't, before they could handle it, because of old age or an illness, that they can't do that work anymore. So that person that provides that care management service can be from our law firm. It can be from, there's organizations that provide those services, so it's out there. So we talked about this. It's encouraging to make this person as independent as possible. That's the ultimate goal. That's what we strive for, to make sure that this person is succeeding in the community as much as they can. Here's just a general list of what the care managers do. They can recommend placement, recommend providers, recommend disbursements from the trust. Hey, this person needs a new washer and dryer because it puked. So that's what Janelle does for us. Hey, trustee, they need new clothing. Can you provide clothing? Can you provide this medical equipment because it broke? They make regular visits to the beneficiary because maybe the trustee that lives in Texas or Florida can only visit maybe once or twice a year. They want to make sure that someone's going out to visit them at least monthly, maybe quarterly, just to get eyes and ears on the situation and report back and see what else is needed. So this is Janelle. This is our care coordinator currently, and she's fantastic. She does a great job. And this is what really sets us apart from other firms is we have this support that we're really proud of. So we're proud of Janelle and her work, and there's other, like I said, there's other care managers out there, other other companies. We have one in-house. So George, I think you're up.
Okay. All right, so we are at about the halfway mark here, and we are only at the very beginning of our presentation. So I'm going to run through the next few slides fairly quickly. If you want to have more in-depth discussion about this, again, feel free to give us a call and set something up, or shoot us an email, something like that, and we can go into more detail here. But we're going to try to catch up so we can get through all of our material. So what are your reporting requirements as the trustee of a trust, of a special needs trust? So to benefit agencies, you have to be ready to report when the trust is created and funded, and when the beneficiary is entitled to distribution. Generally, when mom or dad passes and funds are put into the trust, or when the beneficiary receives that inheritance from out of probate, or receives a settlement award and you create the trust, you need to let all the Social Security and Medicaid know. When you make countable distributions, so that's not things like paying for the care manager or paying for the CPA and whatnot, but if you do make distributions of cash to the individual, or you do some other distribution that that would be considered a countable distribution, you need to report that. And then at any point, the agency can request that you provide a fuller accounting of the trust assets, and its activity, income and disbursements. And when the beneficiary shows income from the trust on their tax return, the agency can request the individual's tax return, in which case those trust reports will show up on there. So,
George, I have a question that I'm going to answer. The question about the fee structure for Janelle services. Janelle currently charges, there is a flat fee structure or an hourly structure. Janelle charges $150 an hour for her services. So it really depends on the circumstance. I've seen, her work for a year could be a few $100s. It could be a few $1,000s, depending on what the need of the beneficiary is. So really, it just depends. You can do a flat fee structure or an hourly structure. All right, we're done with this slide, George?
Yep.
Okay. So I thought, all right.
Okay. So the Social Security reporting requirements, and really this goes broader than just in the context of a trust. I mean, this is just in general. Social Security wants to be notified if the beneficiary changes their living arrangements, if there's a change in their income or their resources, or they become eligible for some other public benefit like HUD housing or Medicaid, something like that. These are all things that can potentially affect the eligibility picture for Social Security. So these are things that Social Security wants to know about. Ethan, you can hit the next slide. So in general, again, about the individual, if they improve medically, physically, to the point where they're no longer meeting that definition of disability, that needs to be reported. If they get married or divorced, that needs to be reported. If they are admitted or discharged from a health facility or a nursing home or something like that, that needs to be reported. And then if they are going to be taking any trip outside the United States, Social Security needs to be notified. I think in general, how often this happens, how often these reports are actually made may not be anywhere close to 100% overall, but these are things that are in the rules. And some of these things are reported on behalf of the individual. I mean, hospitals have to report, to Medicaid about admissions and discharges, and to Medicare. So there's some reporting that goes on behind the scenes as well. So again, if you want to talk about these things in more detail, let us know. We can set something up. All right, and then kind of shifting gears here for the last slide, appealing. If you do receive a denial notice or a notice that benefits are going to be terminated, appealing it. So the general rule is you want to appeal it as soon as you get that notice. Ideally within 10 days, because if you appeal timely, then whatever benefit that you are receiving that is being proposed to be cut off will continue until you have your hearing, and the outcome of that hearing is determined. So, but otherwise, you have up to 60 days to appeal a denial or a termination of SSI or SSDI benefits. Again, you have to get within 10 days of that notice to keep those benefits in place while you are appealing it. For Medicaid, your maximum appeal period is 90 days. But if you appeal, I believe it's within 15 days of the notice date, then you can preserve your fair hearing benefits. Your coverage will continue until the hearing outcome. So what we tell folks is, if you get any notice from Medicaid that makes you worried, let us know right away, because we can, one, tell you whether this is actually something to be worried about or not. Two, get that appeal filed on your behalf, and then three, figure out, is this denial correct? If it's not correct, what do we make sure that gets fixed on appeal? If it is correct, then we figure out, okay, what is the problem? What's the issue that's causing eligibility problems, and get it fixed. So let us know right away if you get any concerning or worrisome notices from any of these agencies.
Okay, so it's very important for you to remember that your trust documents, in fact, all of your estate planning documents, will need to be periodically reviewed. And, as much as we would like it to be, this is not a one and done situation, unfortunately. Trust documents are ever evolving, and they may need to change over time as your family's needs change. And so we have listed, just several examples of things that would require you to at least consider making some changes to your documents. And hopefully earlier I stressed the importance of making sure that your assets and your beneficiary designations are, constantly reviewed. So you need to, stay on top of that and make changes as needed. Similarly, over time, you may want to change some of the people that you have assigned for different roles. The successor trustee might change. Maybe the parents set up the trust when all of their children were minors or very young adults, and it wouldn't have been appropriate for their non-disabled children to serve as trustees. But fast forward 10 or 15 years, everybody's hopefully grown up and become a responsible human being, and it might make perfect sense for the non-disabled children to be the successor trustees. So, that would warrant a change. The beneficiary situation might change. Their eligibility for government benefits, maybe it wasn't a factor, now it is a factor. Your own circumstances might change. You might have significant changes to your own financial situation, and so you want to do things a little bit differently. There can also be, life events. Somebody might die, might get divorced. There could be births, just changes to the family structure. And then, of course, there could be changes to the law that would, make it smart to make some changes to your documents. And on that one, we, of course, very closely monitor any changes to the law. And so if there are things that we think necessitate changes to your documents, we're certainly going to notify you about that. But even if none of those things have happened, just in general, probably every 3 to 6 years, you should have somebody look at your documents just to make sure, do they still reflect the way we want things to be? Will they still protect our loved ones the best way? Okay, let's have the next slide. So now we're going to talk a little bit about Social Security for people with disabilities, SSI and SSDI, and sometimes people get very confused about them and they may not even know which one they're on. We have to start with what is the definition of being disabled. And here the important definition is the Social Security Administration definition. And so we've listed on this slide, what does an adult have to do to be considered disabled by Social Security? They have to have a physical or a mental impairment that is expected to last at least 12 months or result in death. And that disability has to prevent them from engaging in something called substantial gainful activity. And the acronym for that is SGA. And you may see that in different places. And you might be wondering what that is. This year, SGA is $1,550 a month. And typically it goes up a little bit every year. Last year it was $1,470 a month. And what that means is if a disabled person is able to work and they make more than SGA, as far as Social Security is concerned, they are not disabled. And that can be terribly frustrating and seem to not make much sense. You're in a wheelchair, you're clearly disabled, but if you're making more than SGA, you're not disabled in the eyes of Social Security. Okay, next slide. So now we're going to talk a little bit about SSDI and Medicare. Now remember, these are the non-means tested government benefits, okay? So they do not have the strict requirements that SSI and Medicaid have. So you're not cringing every time your bank account goes over $2,000. You do have to be mindful of SGA though. Now SSDI is disability payments that you can get 5 months after Social Security has determined that you have a disability. And then 24 months after you get your first SSDI check, you automatically get Medicare, which is great. And it does not depend on your age. And that can be very confusing to people. Most of us have it in our head that Medicare is for people 65 and older. Well, that's true, but it's also for people who have disabilities who are receiving SSDI. So that's kind of a great perk there. Now, the important thing about SSDI is it's tied to a work history. You have to have worked and paid into FICA enough to have enough credits to qualify for SSDI. And typically, you can only earn 4 credits a year and you have to have 40 credits. So rough rule of thumb, you have to have worked and have been paying into Social Security for 10 years to qualify for SSDI. Now, there are exceptions. The young people who, just calendar-wise cannot have been working for 10 years, they're able to qualify for SSDI as well. But what you have to remember is SSDI is tied to a work history. SSI is not tied to a work history. Okay, next slide. So when we're talking about SSDI, just a really great feature about SSDI is that it is also available to disabled adult children of parents who had enough of a work history that they themselves qualified for either Social Security retirement or for SSDI. So if an adult child was disabled prior to the age of 22, and the parent themselves is either retired and collecting regular Social Security or collecting SSDI or deceased, that adult disabled child is able to collect SSDI based on their parents' work history. So they don't have to have ever worked. And this is great. If your parent is disabled and getting SSDI, or they are retired and getting regular Social Security, the adult child will get 50% of whatever the parent is getting. It doesn't ding the parent share, it's just extra money. And then if the parent dies, the adult disabled child can get 75% of what the parent was getting. And in many cases, this is going to be more than what SSI was, and you don't have to worry about all the restrictions, so it's great. But you do have to be mindful that SGA is relevant here. And what that means is if the adult disabled child is working and they earn more than $1,550 a month, they will lose their SSDI. They won't lose it immediately. There's a trial work period, but they will lose it. They don't lose Medicare for a much longer time. So they can keep Medicare for over 8 years, even if they've lost their SSDI. Okay, next slide. Okay, now we're going to talk a little bit about SSI and Medicaid, and those are the means-tested government benefits. Those are the ones where we cringe when your bank account.
Helen, I'm sorry to interrupt you, but there was a question that came up. What % under child disability benefits does a child get if parent is retired but has 2 children with disabilities? I can take this one. This is so it goes through this complicated formula where there's a maximum family allowance of Social Security benefits. I believe, which I should know this off the top of my head, I think it's around like $4,900 where a household can receive benefits from the breadwinner, which is the highest amount of Social Security benefits that a person receives. It generally it goes from 150% to 180% of that breadwinner's Social Security. So with that being, I mean, it's hard to answer that question because there's a lot of factors that are involved in coming up with this that number, but ultimately the children would receive a reduced amount. They wouldn't receive a 50% or 75% of their parents' work history. It would be, somewhat smaller. Any other thoughts on that, George or Helen?
That was a much more in-depth bit than I was aware of. So you educated me.
All right. Yeah, it goes through a very complicated formula and it all depends on the circumstance, unfortunately. And Social Security makes that determination, internally, and then you kind of have to figure it out once it's determined and then see, okay, this is how it works. All right, go ahead, Helen.
Okay, so SSI and Medicaid, these are the means-tested benefits. Okay, they have very restrictive income and resource limits. So the maximum SSI payment this year is $943 a month. Now, to receive SSI, you have to meet that SSA definition of disability, and you have to have low income, and you have to have less than $2,000 in countable resources. Countable is an important word because not everything is countable. Okay, you can have a car, you can have a house, you can have money in a stable account that we'll talk about, you can have money in a trust. Right? wholly discretionary trust or a special needs trust. But $2,000 is pretty restricted. Now, SSI is intended to pay for food and shelter. And if you are receiving help with food and shelter because somebody else is paying your rent or your mortgage payment or your utilities, or they're buying your groceries, Social Security is going to ding you when they are going to reduce how much SSI you're going to get. And we're going to talk, you know, a little bit later about what the formula is and how they do that. Now, the important thing to remember about SSI is when you have children, parental income deems to the children until they're 18. So oftentimes our children with disabilities are not eligible for SSI until they turn 18 because they don't have any income, but the parents normally have income that exceeds what SSI allows, and so the children will not be eligible for SSI. Then they turn 18, maybe nothing else has changed. They're still living at home and you're still supporting them the way you always were, but they are now an adult and parental income no longer deems to them, and so they very likely would be eligible for SSI. Another nice thing is that since 2016 in Ohio, if you apply for and get SSI, you will automatically get Medicaid. There's no separate application that needs to happen. So that's great. And you know, if your child turns 18 and decide to apply and get them SSI and they get Medicaid, sometimes parents will come back and say, well, we don't really need the Medicaid because, you know, they're on our health insurance and they can stay on our health insurance until they're 26 or in some cases beyond that. That's true, but there's no harm in having Medicaid as secondary insurance. So it's nice that when you get SSI, you automatically do get Medicaid. Any questions about that? Okay, we'll move on.
Okay, so we want to just go over very quickly, you know, the difference between income and resources and nuances to what income is when we're dealing with needs-based benefits. You know, income is a very broad definition for Social Security standards. It doesn't have to be earned income. It can be unearned income. And unearned income can be, you know, income from investments. It can simply be, you know, $500 coming into this account under this disabled child's account every month. That could be considered income under Social Security standards, and that would be unearned income. If it enters the account in that month, that is income. If the money stays in that account after that month, that calendar month, then it becomes a resource or an asset. You have 10 days to report, generally, a change in resources to the Social Security and to Medicaid. It's, you know, 10 days can be pretty, you know, restrictive. That's what it says. We've never seen anyone be dinged for not reporting it, you know, after a 10-day period. So it's just a reasonableness standard here. And what we mean by reporting, you know, we're not talking about, oh, the $20 that was income and then became a resource. We're talking about an inheritance that this person received or some kind of money that this person received, you know, a substantial amount to make them, you know, that make a huge change in circumstances. Income, when dealing with SSI, this is the general rule of thumb, and this is the general, you know, worksheet that they have. If someone is receiving SSI, but also receiving income from another source, you disregard the first $20 of unearned income. if it's earned income, you disregard the first $65 and then plus 1/2 of the earned income. So as Helen pointed out, the SSI rate is $943 a month. And if you make $500 in income, well, from working a job, let's say, so it's earned income, it's that $500 gross, $65 is disregarded, and then 1/2 of the remaining. So that's about $215 or so. I wish I could do math like that at the top of my head. But it's around, so that $215 would be reduced from their SSI the next month. So next month they will receive about $700 or so. There's other deductions from the income if you have impairment related work expenses, that could be deducted. There's deeming issues, which is why a lot of minor children do not receive SSI, is because their parents' income and assets deem to that minor child. We talked about in-kind support and maintenance before. That's that food and shelter expenses. Food and shelter paid by a third party, whether that's the parents, whether that's from family members or their trust, that will reduce their SSI by at least 1/3. And then the Medicaid spend down with income in Ohio, where some states have a spend down, but in Ohio, if you have income, you can, in some states you can push that income out with spend down, eligible expenses that can be spent in order to still qualify. But that's not the case for SSI, and that's not the case for Medicaid in Ohio anymore. Resources, they need to be owned by the individual and available to the individual. So those are two key points of what a resource is. If it's unavailable to a beneficiary, then meaning that it's locked in this account and there's no way of them accessing the money, then it's not a countable resource to them. That's a very rare circumstance, but that happens sometimes. It happened to a client of mine who was receiving, he was 18, but he had $5,000 in a it's called an UTMA account, a Uniform Transfers to Minors Act, and that he didn't have access to the account. It wasn't available to him until 21. So technically it was, even though he was titled to it, he owned it, he wasn't the manager of the account because it was under an UTMA account. So SSI and Medicaid allowed him to receive benefits even though this account was hanging over his head. So we talked about deeming, and we talked, and why that's important. When you have a disabled minor child, they won't receive any SSI or Medicaid because of their parents' income and assets, resources. Generally, these are the main exempt resources, non-countable resources. It's household goods, a primary residence, one vehicle of any value, the irrevocable funeral contract, the pre-need funeral plan, a burial plot. The life insurance would be if the total face value of the life insurance is under $2,000. That could be exempt. There's other, and then obviously our trusts and stable and able accounts, which we will talk about at the end here, the Stable and Able Act. But these are the main exempt resources. There's other exempt resources, but they don't come up as often. But whenever you're going over your plan, talk about everything that this person owns or might own in the future, and with your attorney, and you can put together a plan. A question just came up about Medicaid buy-in for workers with disabilities. That's going to come up in about 5 minutes. So George, you can take it over.
Yep, just a couple of slides. So we're going to talk about what Medicaid benefits there are, how they work a little bit, then as well as some things like Medicaid waivers and other programs, including Medicaid buy-in for workers with disabilities. So basically, Medicaid provides health insurance, medical assistance. That's primarily what it is for. So it is basic health insurance, so covers hospitalization, outpatient treatment, prescription drugs. It can also cover medically necessary in-home care or personal care services. Typically, this is done through one of the Medicaid waiver programs, which we'll talk about here in a minute. Medicaid can also pay for durable medical equipment, wheelchairs, oxygen tanks, things like that. Medicaid standard is that it has to be medically necessary, which it can be surprising some of the things that Medicaid may not consider to be medically necessary, particularly in the cases of dental and vision care. But by and large, Medicaid is fairly comprehensive, and the idea is there should be little to no out-of-pocket costs under Medicaid health insurance, health coverage. Again, the intention is that this is to cover people with minimal to no resources.
George, I had a question here that came up. If a beneficiary does not receive SSDI due to earnings above SGA, can the beneficiary put money into the special needs trust to lower resources or just save? Well, what you're asking in this question is you're confusing income and assets. The income would kick them off SSDI. It's not a resource. So what many families have to juggle is, can this person, make more money to get them off SSDI and off their benefits, or do we have to limit how much they work in order for them to keep their benefits? So you're stuck between a rock and a hard place. Can this person work and be out in the community as much as possible, or do we have to limit that in order for them to receive Medicare or their Medicaid and Medicare and all their benefits? So that's, obviously we recommend is to try to keep their benefits, to try to limit their hours, because it's a pain to get those benefits back after you lose them. But that's a case-by-case basis. Some families say, no, we're going to let them work as long as possible and as much as possible, and they might lose their benefits because of that. And that's okay. That's okay. So go ahead, George. Sorry.
Yeah, and just to piggyback on the end of that, there's a subtle distinction there between when somebody is earning more than the SGA amount. It's not, SSDI does not have any means testing, so it doesn't matter how much income somebody receives. If somebody receives, if somebody's getting unearned income in excess of the SGA amount, that's not a problem. It's when somebody is earning more than that SGA, it's that they are now definitionally no longer disabled. So in a lot of other contexts, we can do things where we can assign income to trusts, or we can do other things where we get somebody below an income eligibility limit. But specifically for the SSDI, it's the fact that they're earning enough income that they are no longer disabled by definition. So there's a subtle distinction there, but it's an important one.
Here's another question, George. Can the trustee purchase additional medical insurance for the beneficiary to meet their needs? Will this affect Medicare or SSI?
So the answer is maybe. So there, in general, the way that the insurance works with Medicare and Medicaid is that Medicaid is always going to be the insurer of last resort. So for an individual, so for example, an individual that is what's called dual eligible, they're receiving both Medicare and Medicaid benefits, then Medicare is their primary insurer, and Medicaid covers whatever Medicare does not. Medicare has limits on Medicare comes with copays, and it comes with lifetime limits and per incident limits and things like that. So Medicaid can pick up from there. Additionally, a Medicare beneficiary can purchase a Medicare supplemental plan or enroll in a Medicare Advantage plan, and there are some options for individuals under age 65. There are Medicare Advantage plans that they can enroll in, and that simply adds one layer to the insurance picture. So if you've got a supplement, Medicare is primary, then the supplement, and then anything that those two don't cover then falls to Medicaid. So generally speaking, Medicaid is going to be the broadest coverage that an individual can have. Medicaid by and large does not have any copays. It doesn't have out-of-pockets. It doesn't have premiums, with certain exceptions. But by and large, it's sort of the base level of health insurance that you can get. So in general, if you're on Medicaid health insurance coverage, there may not need to be a reason to go out and get supplemental coverage for health insurance. Now, we can talk about other services and things like that, but that's the basic idea of how that insurance all works. So Medicaid has a myriad of programs. So your base Medicaid eligibility, if you are a low-income adult under age 65 who's not disabled, then you can get what's called MAGI coverage. That's the expansion Medicaid as a low-income adult. For individuals who are disabled, they fall under the original Medicaid rules that are fairly restrictive asset-wise. $2,000 and under $943 in income. So we frequently see folks who, if they go from SSI to SSDI, again because their parent retires or passes away, they're okay income-wise because they're grandfathered in essentially. But that higher income means they start accumulating assets, and now they're knocked off of their their Medicaid. Or an individual who is determined disabled, but they're in that 2-year waiting period before their Medicare coverage starts. But their disability coverage is higher than the income limit. They can be in a tough spot until that Medicare coverage kicks in. But beyond that, Medicare, Medicaid health coverage, Medicaid funds a lot of other programs that provide care services and other supports to individuals who have those needs. And we refer to these as the Medicaid waiver programs. And it's a little confusing, I think, that they're known as the waivers. And what that refers to is it's not the individuals who are asking for a waiver from anything to get these benefits. You're not requesting an exemption or special treatment. That waiver refers to the fact that the state has received permission from the federal government, from Centers for Medicare and Medicaid Services, to use federal and state Medicaid funds for services that aren't part of their original Medicaid plan. So, for example, the the Medicaid waivers, the home care, assisted living, and passport waivers. These are permission to use dollars that would have otherwise gone to the nursing home care Medicaid to be used for other services to support that same group of people, that same population. So don't let the waiver word trip you up. These are programs. They're Medicaid programs that are there to provide services and supports in addition to health coverage. So we'll jump in here. Specialized recovery services. This is another one of those programs. This is an interesting one. It's really beneficial, and it is aimed at two fairly discrete and distinct groups. The first being individuals who have what's called a severe and persistent mental illness. So the people with severe schizophrenia or severe psychiatric disorders who need quite a bit of support in their day-to-day life, and also people who have severe chronic conditions, cancers, immunodeficiency syndromes, end-stage renal disease. There's a whole list of qualifying conditions. This program is something they are also eligible for. Specialized recovery services has a higher income threshold. It's this year it's $2,829 per month, which is much higher than the $943 traditional age blind disabled Medicaid limit. And it provides services that are intended to help the individual make it while still living in the community. So everything from vocational training to group therapy, counseling, case management services, whatever the individual needs. There's a whole host of services that specialized recovery services can provide. The best part about specialized recovery services is that under the rules, there is no asset limit, no resource test. It is strictly based on income. So an individual who has some savings and money in the bank because their condition allows them to work sometimes and accumulate, but then they're unable to work for a period of time. They can continue to receive these specialized recovery services without having to shuffle their assets or spend things down or anything like that. So it is a really neat program that is a way to get additional health coverage for individuals, and this is really beneficial for, like I said, in that gap when you're determined disabled and you're starting to get your SSDI, but it's too much for traditional Medicaid, but you're not ready for Medicare yet. SRS can fill the gap there if you have one of those qualifying conditions. And then we have our Medicaid buy-in for workers with disabilities. So this is for individuals who are disabled, who meet that definition of disability, but they are still nonetheless able to work. Medicaid rewards that because by giving you a higher threshold and a broader eligibility criteria to continue receiving Medicaid. Now, this may require that the individual also pay a premium if their income is high enough, but this allows them to be out there in the workforce without having to worry about not having medical coverage. So it's a good program, and one that really benefits quite a few folks. I see there's a question there in the chat about, are these incomes gross or net? All the numbers that you see in our slides that are referring to income are all reflecting gross income. When you're then doing that eligibility evaluation, there may be some deductions and disregards from there, but the starting point is always at gross income, whether usually monthly income is your starting point for analysis. So gross income is the key there. All right, and then SSI, this is the, the means tested benefit for individuals who don't have the work history to collect SSDI, don't get grandfathered in as a disabled child. It provides cash assistance to the individual with the intention that cash assistance is there to meet that person's basic needs. And this is the point in the program where I always point out that the rate of SSI, the amount that you get as an SSI recipient is by definition below the federal government's poverty level standards. So by definition, being an SSI recipient and relying on that for your basic needs means that you are a person living in poverty. I won't get up on my soapbox too much more, but I think that's always something that ought to be pointed out when we talk about this. SSI, yeah, I think that's enough there. We are coming up on our limit here. So, Helen, I believe it's over to you.
Yeah. Okay, so I'm going to speed through these next couple of slides. We've mentioned several times this morning that SSI is intended to pay for food and shelter. And if the recipient is getting help with food and shelter from a third party, their SSI is going to be reduced. The good news is it's not necessarily a dollar for dollar reduction. There is a formula. So they call this in-kind support and maintenance, ISM, very big on acronyms at Social Security. And the maximum that your SSI can be reduced if you're receiving help with food and shelter this year it's about a third of whatever the SSI for the year is, which is $943 a month. So it's a third of that, plus they add $20. So the maximum, which is the PMV, the presumed maximum value, is going to be this year $334. So Social Security can say, hey, you got help, you're living at home with your parents, or they're paying your rent, or they're buying your groceries. Instead of getting $943 a month, you're going to get $609 a month. That's the maximum that they can reduce it to. So if you have your child living in an apartment and you're paying $2,000 a month for their rent, they're not going to lose their entire SSI. They are going to get it reduced from $943 to $609. We have a couple of examples. I think if you go to the next slide, they're just math examples, and they're going to take you through, hey, somebody bought me $50 worth of groceries, how's it going to be reduced? So you can kind of work through that yourself. I think we have more important stuff that I'm mindful we only have a few minutes left on, so I think we should skip ahead now.
So I'll jump in here then for talking about the transition timeline. This is when an individual turns 18, they are now an adult, and their benefits picture is evaluated based on their own information, and by and large, their parents' assets and eligibility is no longer really a factor. Typically when that disabled child turns 18, they are likely still to be living at home. They are likely to still be going to school, but they are now an adult. So what does that mean? Well, parents are no longer automatically the decision makers for them. It is usually prudent to then obtain guardianship or some other legal ability to act on your disabled adult child's behalf now, whether that be appointed as a court-appointed guardian or have that child execute a durable power of attorney so that you can act on their behalf as their agent. Now having the parents let the child live at home rent free and provide, you know, their meals, now this becomes in-kind support and maintenance to that child. So what we want to do in those situations is we want to have the child enter into a formal agreement with their parent to pay them, you know, pay them room and board, so that they aren't deducted, you know, their SSI isn't reduced because mom and dad are providing free food and shelter. Then further on down the line, and we've talked about this a couple of times now, you know, when the parent, you know, passes away or retires, if that disabled child is a disabled adult child, a DAC beneficiary, they move over from SSI to SSDI. They receive a portion of their parents' benefits. They become eligible for Medicare. So long as their resources stay below $2,000, they're still going to be eligible for Medicaid, even though their income has gone up. So it's one of the rare bits of just pretty much 100% all good that benefit that you get from our typically otherwise very stingy federal benefits programs.
So we have this next topic. We have 4 minutes left, but I'm just going to go over the trust that we use very quickly. Essentially the two trusts that on the broadest sense of the trust that we use is a third-party trust and a self-settled first-party trust. The self-settled trust is the one with the Medicaid payback provision, and the third-party trust does not. They virtually work the same, except for those two huge, that one huge difference is that Medicaid payback. So the question that comes up is, Ethan, why don't we use a third-party trust all the time? Well, you cannot put first-party money in a third-party trust. And if you put third-party money in a first-party trust, well, you just lost that money in that Medicaid payback provision if that beneficiary dies. So you never want to commingle where the sources of money are coming from. The trusters are designed to hold that money for that reason. So a third-party trust is what we use for estate planning purposes, for parents, grandparents, whoever. You know, I could set up a trust for someone, for a client, and people can fund this trust. Anyone can fund a third-party trust. Anyone can make a third-party trust for anyone else. We also use a third-party trust for Medicaid planning for grandma or a parent that they need to go on Medicaid. They can, you know, put that money aside in a third-party trust and get themselves on Medicaid. The first-party trust, this money is owned by that individual. It comes from inheritance, from litigation, from the child support, and especially in castle cases, and an improperly drafted third-party trust. So the Medicaid payback, the general rules are it's established by these people or the beneficiary if they are disabled and under the age of 65, and it has that payback provision at that beneficiary's death. There's also the pooled trust. This can be either a first party or a third party. It's managed by a nonprofit organization. There is a lot of red tape dealing with a pooled trust, but they can invest the money, and they can, if there's no trustee there, then, you know, to manage this money, well, that's why this pooled trust is there to, you know, help manage this money for the individual. So we're running out of time. We've got a few seconds left. I think that we can do something with this able and stable account. I think that, you know, maybe we can do something separately. Because that's what the last 10 or so slides are about.
A 1-minute summary, because I think
Sure.
it's important. Okay, so a lot of you are familiar, some may not be. Able, sometimes stable, people are like, what's the difference? Able and stable in Ohio are basically the same thing. Able's a federal national term, stable is our program in Ohio. Very easy to set up. You do it online, you don't need us or an attorney to do it. Basically, it's a way that a person who's receiving government benefits can save money above and beyond what those benefits normally allow without screwing up their eligibility. So this year, you can put a maximum of $18,000 into a stable account, and it doesn't impact your SSI or your Medicaid. Over time, this can accumulate. You won't lose your SSI unless you have more than $100,000 in an ABLE account. You won't lose your Medicaid unless you have more than $523,000 in a stable or ABLE account. We would never recommend that you put that much money in a stable or ABLE account. Think of it as an operating account. It, like a first-party trust, has a Medicaid payback requirement. So you don't want to have $500,000 there when the beneficiary dies, because Medicaid's going to take it. So there's some limitations. You can only put $18,000 a year there. So if somebody leaves your child $50,000 in their will, you can't stick it all in a stable account. But it gives you some breathing room from that $2,000 requirement. Very easy to set up. You can use money in an ABLE account for almost anything. Anything that's a qualified disability expense, I'd be hard pressed to come up with something that's not a qualified disability expense. It's a good partner to a trust. You can use it to pay food and shelter. There's no requirement that you don't use it for food and shelter. So you can have a trust where you're accumulating the money, and then you can move money to a stable account. You can go to stableaccount.com to learn more about it. You can set it up in 15 or 20 minutes. Anybody's eligible who has a disability that occurred before they were 26 years old, as long as they meet the Social Security definition of disability. And that's going up to 46 in 2026, so more people will be able to have them. Anyway, sorry to speed through it, but I think it's a tool worth looking at.
That's okay. I think that we'll do either a blog or maybe even a separate video on stable accounts, because they are important and there's a lot. It's a very helpful tool in the toolbox for our special needs clients. You know, a lot of clients have a third-party trust, a first-party trust, a stable account, a representative payee account with their Social Security. So there's a lot of hats involved that could be there for one individual. So, well, that's all we've got for today, everyone. So thank you very much. We will be putting these slides, and we will be putting the this presentation on our website. So we will send an email out to everyone, and to everyone that's participated and not participated. Thank you very much, everyone, and have a great weekend. And last snow of the season, fingers are crossed, and we're ready for spring then. So thank you, everyone.
Don't forget to change your clocks.
That's right. That's right. A lot of stuff happening.